relying on Oyetola and INEC citations supplied. He urged the court to hold that the failure did not substantially affect the result of the election, which was properly collated and result announced. In his argument, Chief Atiku said, for the second respondent, submitted that by all extant relevant laws, INEC has the prerogative of determining the mode and manner for the transmission of election results, and that the respect to the presidential election in focus on their claim that the results of the election results were not electronically transmitted to the IREP in real time, not that it was not transmitted at all,
and that the first respondent did not ensure that the results were collated on the IREP. He also faulted the appellant's insistence that the results ought to have been collated
electronically on the IREP, and that omitting to do this automatically nullified the result of the election. Referring to the case of Labour Party and INEC, suit number FHC ABA-CS 145/2022, delivered on 23/1/2023 by Wite J of the Federal High Court, which decided that there is nothing in a combined reading of sections 47(2), 52, 65, and 62, 1 and 2 of the Electoral Act 2022, which suggests that INEC is mandated to only use an electronic means in collating or transferring of elections result. Rather, that INEC is at liberty to prescribe the manner in which election results will be transmitted. That by section 287(3) of the 1999 Constitution, all authorities and persons are bound to enforce the terms of the judgment until set aside by an appellate court. It submitted that all through the gamut of the Electoral Act, the appellants were unable to refer to the lower court a single provision which prescribed electronic collation of result or even electronic transmission of results, and that was why the court below held that the petitioners were unable to prove that the Electoral Act or guidelines made it mandatory for electronic collation system.
He submitted further that the appellants failed to show that the results collated was different from the one they perceived belonged to them. Leonard Silk submitted finally that the Electoral Act 2022, the INEC regulations and manual
points irresistibly to a manual collation of results, contrary to electronic
collation touted by the appellants. The reason being that by paragraph 93 of the regulation, the only circumstance where electronic copy of results becomes relevant is where there is no hard copy of the result. Then the electronic copy can be resorted to during collation. Learned counsel Atiku urged this court
to resolve this issue against the appellants. In his submission, Chief JUDGEMENT for the third respondent submitted that the appellants seem to have admitted their failure to prove allegation of non-compliance when they pleaded with this court to depart from the earliest established legal position that non-compliance be proved on polling unit basis. He submitted that there is nothing compelling presented by the appellants to warrant a departure from the established legal order, relying on Wike and Peterside, Belgore and Ahmed citations supplied. He urged this court to decline the invitation. According to Leonard Silk, any agreements for relaxing the established standard of proof of allegation of non-compliance
must not be driven by sentiments and cavalier presentation of a case seeking to overturn the will of millions of the electorate in the presidential election. He contended that the appellants merely half-heartedly offered 27 witnesses, many of whom were incompetent witnesses, while purporting to prove allegation of non-compliance covering 176,000 polling units spread across the 36 states that make up the Federation of Nigeria. He argued that based on the inadequate evidence, the allegation of non-compliance must fail, relying on Buhari and Obasanjo, Atiku Abubakar, and INEC, all citations supplied. He urged the court to resolve this issue against the appellants. In their reply brief, the learned senior counsel for the appellants faulted the response of the respondents in relation to their call for this court to depart from its previous decision touching issue of non-compliance.
According to him, his argument is based on the introduction of Section 65 and 6 and 187 of the Electoral Act 2022 and paragraph 46 of 4 of the first schedule to the Electoral Act, which provisions were not in the 2010 Electoral Act. That these new provisions deal with the new manner of transmission of result as contained in paragraph 38(1) and 2 of the Regulations and Guidelines for Conduct of Elections 2022 and the legislative intervention to reduce calling of numerous witnesses. This is what the court has to say. By Section 135, sub 1 of the Electoral Act 2022, an election shall not be liable to be invalidated by reason of non-compliance with the provisions of this Act if it appears to the election tribunal or court that the election was conducted substantially in compliance with the principles of the Act and that the non-compliance did not affect substantially
the result of the election. From the provisions of the Act stated above, it is crystal clear that a petitioner seeking to nullify an election on the ground of non-compliance must not only lead evidence to prove the non-compliance, but must also show to the court how the non-compliance substantially affected the outcome of the election. A petitioner in this situation must therefore adopt a kind of double-barrel approach. You don't fire one barrel and leave the other intact. Both must be fired together at the same time. From the evidence as can be garnered from the record, the judgment of the court below and the arguments of both parties in this appeal, one thing is very clear, and that is the appellants abandoned the duty imposed on them to lead credible evidence to prove non-compliance, but relied solely on the failure of the first respondent to transmit result real-time to the IREF portal. According to the appellants, this was enough to nullify the election of the second respondent. What exactly is the IREF portal? The court below held that the IREF portal is not a collation system. This court in Oyetola and INEC made it clear that there is a difference between a collation system and the IREF portal, though both are part of the election process. Whereas the election system is made up of the centers where results are collected at various stages of the election, the INEC result viewing portal is to give the public the opportunity to view the polling unit results on the election day. What this means is that where the IREF portal fails, it does not stop the collation of results, which up to the last election was manually done. The failure or malfunctioning of the IREF deprives the public and even election administrators and monitors the opportunity of viewing the portal and comparing the result collated with the ones transmitted into the IREF. Truth must be told, the non-functioning of the IREF may also reduce confidence of the voting public in the electoral process. My lords, the Electoral Act empowers the first respondent to determine the electronic device to be used during election and their purpose.
The lower court held that the IREF is not a collation system, and I agree. I refer to paragraph 93 of the first respondents' guidelines and regulations for election, which provides that, and I quote, where the INEC hard copy of collated results from the immediate lower level of collation does not exist, the collation officer shall use electronically transmitted results or results from the IREF portal to continue collation. When none of this exists, the collation officer shall ask for duplicate hard copies issued by the Commission to the following in the order below. 1, the Nigeria Police Force, and 2, agents of political parties. End of quote. Paragraph 93 of the first respondent's guidelines and regulations reproduced above shows clearly that recourse to the electronically transmitted result for the purpose of collation will only arise where the hard copy of the result sheet does not exist. Given when the electronically transmitted result or the result on the IREF portal does not exist, the Commission will ask the copy or agents of political parties. The elaborate arrangement made by the first respondent for collation of result is to make sure that at every point of collation, there is a result either from the hard copy with INEC or the electronically transmitted copy or the IREF portal copy or a hard copy given to the Nigeria Police, and finally, or a copy given to political parties. I think I can confidently say, and in agreement with the respondents, that the unavailability of the election results on the IREF portal, for whatever reason, cannot be a ground upon which an election could be nullified, particularly as it is not the case of the appellants that the hard copies of the result sheets did not exist at any level of collation. My Lord, having failed to prove judgments were or that there was any miscarriage of justice since of this society. Section 187 electoral relied upon by the appellants for the failure to prove non-compliance in the manner whereby is non-compliance with the conduct of election to court oral evidence if originals or certified copies manifestly disclose the non-compliance. The above provision has not absorbed the addition of the inexplicable evidence to prove non-compliance. It is clear that oral evidence may not be necessary if and only if originals or certified copies manifestly disclose non-compliance. In this case, the appellants have not demonstrated the originals or certified copies of documents they want to report to the Parliament. Even where such documents are entered in evidence, it is to be sure that they manifestly disclose the non-compliance. On the whole, these are well considered claims which are part of the views of this court, the court below, that the failure to transmit the result of the act did not affect the result of the election. Accordingly, this issue is resolved against the appellants. The second issue is whether the court below was right in its interpretation of the provisions of Section 184 2B and Section 299 of the Constitution of the Federal Republic of Nigeria as amended, in holding that securing one quarter of the ground votes cast in favor of the Federal is a constitutional constitutional requirement of the valid return of the candidate as the newly elected President of the Federal Republic of Nigeria. It is argument that the Legislative Council for the President of the Federal Republic of Nigeria. In his argument, the Learned Senior Counsel for the appellants urged this court to interpret the word "and" in Section 134 2B
of the Constitution conjunctively and not disjunctively, which will make it compulsory for a candidate to score a quarter or 25% of votes cast in the Federal Capital Territory
before he can be President of the Federal Republic of Nigeria. The respondents argue otherwise. My noble lords, on pages 8234 to 8235 of Volume 10 of the Record of Appeal, the lower court made the following decision, and I quote, "As expressly stated in Section 299 of the Constitution for the purposes of fulfilling the requirements of Section 134, Sub 2B of the Constitution for the return of a presidential candidate as duly elected, the Federal Capital Territory, Abuja, is to be treated as one of the states in the calculation of 2/3 of the states of the Federation, such that if the candidate polls 25% or 1/4 of votes in 2/3 of 37 states of the Federation, FCT inclusive, the presidential candidate shall be deemed to have been duly elected, even if he fails to secure 25% of the votes cast in the Federal Capital Territory, Abuja, as the second respondent did." End of quote. To be very honest, I do not see anything wrong with the above decision. It is basic that one of the vital concerns of interpretation of statutes is that a court of record should be minded to make broad interpretation, or what is sometimes referred to as giving same a liberal approach. A court should give a holistic interpretation to a statute or the Constitution as required by law. Probably I may add that a court must give the Constitution or a statute a purposeful and people-oriented interpretation. What I'm trying to say is that in interpreting the Constitution, or any statute for that matter, a narrow and selfish approach, the duty of the court in interpreting statute should be in such a way that it serves the generality of the people and not for a select few. It is tried that the legislature does not intend creating injustice or an absurdity. Hence, the court must always adopt a construction or interpretation which will not reduce legislation to futility and absurdity. See, Governor of Kwara State and Dada, citation supplied. Let me drive this matter home. The poster rendered by the learned senior counsel for the second respondent in their brief comes handy. Assuming that a candidate scores the highest number of votes in a presidential election and has 25% or 1/4 of votes in 30 out of 36 states and Abuja, but failed to secure 25% in the FCT, are we saying that he cannot be president? Is that what the Constitution intended? I don't think so. The court below made it very clear when it held that if the framers of the Constitution had wanted to make the scoring of 1/4 of votes cast in the Federal Capital Territory a specific requirement for the return of a presidential candidate, they would have made that intention plain by using words that clearly separate the scoring of 1/4 of votes in the Federal Capital Territory as a distinct requirement. End of quote. The above decision of the lower court is unassailable, and I have no difficulty in agreeing with it. I see no merit in this issue, and I resolve it against the appellants. Issue 3 calls on this court to interrogate the decision of the court below and answer the question whether the lower court was not in error to have expunged the witness statements on oath of appellants subpoenaed witnesses, namely PW 12, 13, 14, 15, 16, 17, 18, 21, 23, 24, 25, 26, and 27, and the exhibits tendered by them on the ground that the witnesses' statements on oath were not filed along with the petition, and that Order 3, Rule 2 and 3 of the Federal High Court Civil Procedure Rules 2019 is not applicable in election matters. Learned senior counsel for the appellants for the decision of the court below for relying on paragraph 4 of the first schedule to the Electoral Act, failure to apply the provision in Order 3, Rule 2 and 3 of the Federal High Court Civil Procedure Rules. He submitted that the interpretation given to paragraph 4.5b of the first schedule to the Electoral Act 2022 by the lower court in disallowing the testimonies of the appellant's subpoenaed witnesses will only lead to absurdity and prevent petitioners from compelling relevant evidence in possession of an adversary. In reply, the three senior counsel for the respondents in their various briefs
submit in unison that the 21 days prescribed for filing the election petition cannot be extended under any guise,
and that paragraph 4.5b of the first schedule to the Electoral Act cannot be enlarged to accommodate witnesses' statements on oath, which were not filed along with the petition. That having responded to the petition based on the facts and witnesses' statements front-loaded, their right to fair hearing will be trampled upon by allowing new evidence through those witnesses when they have no right to further reply. They urge the court to resolve this issue against the appellants.
Let me reiterate the already tried position of the law that the election petition is sui generis. That is to say, it is in a class of its own. As was held by this court in Abubakar and Yaradua, this is no longer a moot point. It is different from a common law civil action. In Kalu and Uzo, citation supplied, this court stated clearly that the Electoral Act of whatever version, particularly that of 2022, contains mandatory provisions. Thus, election petitions have certain peculiar features which make them sui generis. They stand on their own and bound by their rules under the law. It was further held that defects or irregularities which in other proceedings are not sufficient to affect the validity of a claim are not so in an election petition. A slight default in compliance with a procedural step could result in fatal consequences for the petition. It has to be noted that rules governing civil proceedings are not the same which govern election proceedings. And where the Electoral Act requires recourse to civil procedure rules, it must be made subject to the provisions of the Acts. My noble lords, a combined reading of Section 285, sub 5 of the Constitution of the Federal Republic of Nigeria as amended, and paragraph 4.5 of the first schedule to the Electoral Act 2022 shows that the time limit for the filing of written statement on oath of witnesses in election petition proceedings is 21 days from the date of declaration of results. As was pointed out by counsel for the respondents, due to the sui generis nature of the election proceedings, amendment to the petition or calling of additional witnesses will not be entertained after the statutory time limit for the filing of petition has expired. Thus, a petitioner cannot present his case in bits, otherwise the respondent's right to fair hearing will be breached. This was the position of this court in Oke and Mimiko, citation supplied. In his contributory judgment in the above case, Clara Ogumbiyi JS retired, made the following decision, and I quote, by paragraph 4, sub 1 and 5 of the first schedule to the Electoral Act, a composite analysis of the contents of an election petition has been spelled out, and also a list of materials which must be accompanied. The use of the word shall in the subsections is very instructive. It is mandatory and conclusive. In other words, the provisions do not allow for additions, and hence the procedure
adopted by the appellants in seeking for extension of time is nothing other than surreptitious attempt which provides for extension of time. What is more, via paragraph 14(2) of the first schedule to the Electoral Act, the appellant by section 135 Act had been totally foreclosed from any amendment, which was in fact the hidden agenda promoting application. Further still, and on a critical perusal of the application, Relief 2 seeks leave to call additional witnesses, to wit AEO. It is pertinent to restate that at the close of pleadings, parties had submitted the list of witnesses who were to testify together with their deposition. The idea, purpose, and intention of the application is suggestive of nothing more than a clear confirmation seeking an order for an amendment as rightly and ingeniously thought out by the trial tribunal and also affirmed by the lower court. This will certainly violate the provisions of section 285 sub 5 of the Constitution and section 134 of the Electoral Act. End of quote. It has to be emphasized that the use of the word shall in paragraph 4(1) and 5 of the first schedule to the Electoral Act makes it mandatory and conclusive. The question may be asked, can a court extend time circumscribed by the Constitution for a party to do a thing he could not do before the expiration? The obvious answer is no. Such provisions like section 85 sub 5 of the Constitution are mandatory, and any exercise of discretion by the court is without jurisdiction and therefore a nullity. In APC and Marafa, citation supplied, this court held that application of time to call additional and file additional witnesses' statements after the prescribed period for presenting election petition are not permitted because election matters are time-bound, and by reason of being sui generis, the procedure in handling them are stricter than ordinary civil matters. See also Ararume and INEC citation supplied. The impossibility, and that subpoenaed witnesses should be allowed to testify. But as was argued by the learned respondent, A.B. Mahmoud SN, subpoenas and the effect and purpose of 5 of the Constitution of the Federal Republic of Nigeria and paragraph 4(5) of the first schedule to the Electoral Act 2022. It is on this note that I hold that the decision of the court below to strike out the offending witness depositions cannot be faulted. I resolve this issue against the appellants. Issue 4 orbits around the evaluation of evidence of PW1, PW2, 3, 5, 7, and 22, who were the appellants' coalition agents at the court below. The appellants are aggrieved by the verdict of the court that witnesses a hearsay, thus inadmissible under the rule of evidence. For the purpose of clarity, I shall herein reproduce, albeit extensively, the observation of the court below, which led to the verdicts complained about as follows. Analyzing results of the election at the ward, local government, state, and national level without calling polling unit agents who witness the real casting of votes and events at the voting units cannot therefore arise. They cannot validly testify as of non-compliance at the polling unit level. Their evidence can only count as to what they saw, not what they were told by their field agents. What they were told is hearsay evidence. Section 38 of the Evidence Act 2011 specifically states that hearsay evidence is not admissible except as provided for in the law. It follows that the evidence of the coalition agents in this instant case, who are PW 1, 2, 5, and 2 and 7, relating to suppression of votes, multiple thumb printing of ballot papers, entering of wrong scores results, disruption of voting are inadmissible hearsay and are hereby discounted as end of quote. Without reservation, I endorse the above statement of the lower court, which is consistent with plethora of decided cases on the subject, Buhari and Obasanjo, Ladoja and Jumobi, and others cited. From the evidence on record, it is indisputable that PW 1, 2, 3, 5, and 7, who were the appellant state coalition agents and national coalition agents, were not present in all the polling units, which results they have disputed, which means that their evidence in respect of all the polling units, other than the ones that they were present, were clearly hearsay. They were most likely informed by the polling unit agents who were alive but failed to testify. I must say that the above statement of the lower court had nothing to do with the court's failure to ascribe probative value to documents put in evidence pursuant to Section 137 of the Electoral Act 2022 and paragraph 46(4) of the first schedule to the Electoral Act, as vehemently submitted by the appellants. Indeed, the point is instructive in view of the fact that the court had earlier on page 8,102 of the record rejected and overruled the third respondent's preliminary objection, seeking that documents tendered by the appellant be expunged for being dumped on the court. The finding of the lower court in discountenancing the evidence analysis of PW 1, 2, 3, 5, and 7, same being based on hearsay, cannot be faulted. More so, the appellants have not presented any argument to warrant the interference of this court with the finding of the lower court. The issue, again, is resolved against the appellants. Issue number 5 is whether the lower court was not in error in striking out several paragraphs of the petition and the replies of the appellants on the ground of vagueness and lack of specificity and for being new issues, mere denials, or being repetitions. Well, this issue relates to the ruling of the court below on the first respondent's preliminary objection, seeking an order of court striking out 31 paragraphs of the petition on the ground that they were vague, generic, imprecise, and lacking in specificity to elicit reply from it, and contrary to paragraph 4.1 of the first schedule to the Electoral Act 2022. The court, after scrutinizing each of those paragraphs in a well-considered ruling, struck out 10 paragraphs, namely 92, 95, 98, 121, 126, 129, 133, 143, 144, and 146 for being vague, imprecise, and lacking in particulars. For the purpose of clarity, the court held on page 8025 to 8026 of the record as follows. The sum total of all the foregoing is that while paragraph 129 and 133 of the petition are liable to be struck out for non-joinder of necessary parties, to which Messrs. Adejo and Governor Yahya Bello of Kogi State, accused in the petition of committing electoral malpractices, paragraph 92, 95, 98, 121, 126, 129, 133, 143, 144, and 146 are vague, imprecise, and lack of particulars, and so fall short of the requirements of paragraph 4(1)(b) of the first schedule to the Electoral Act 2022. They are therefore all others struck out. Paragraphs 93, 94, 96, 97, 99, 100, 101, 102, 104, 105, 108, 109, 110, 111, 112, 113, 14, 115, 116, 118, 119, 120, 122, 125, 130, 134, 138, 139, 140, 141, 42, 145, on the other hand, are in order and properly pleaded, end of quote. Picked by the above ruling, the appellants now seek the interference of this court on the ground that their averments were sufficiently detailed. They also question the decision of the court, striking out their replies to the respondents' replies to the petition. For instance, as touching on the disqualification of the second respondent from contesting election for the office of president, which particulars were supplied in the appellant's reply. It is instructive to note that in paragraph 146 of the petition, the appellants simply averred that, quote, the second respondent was at the time of the election not qualified to contest the election, not having the constitutional threshold, end of quote. They did not supply the particulars of the threshold, which they perceived disqualified the second respondent from contesting the election, as enumerated in Section 137 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. Howbeit, in their reply, the appellant ruled out monstrous particulars of disqualification by reason of dual citizenship, allegation of being an ex-convict in a USA district court, having forfeited to the USA the sum of $460,000 in a drug-related case, Note that these particulars referred to as further details were brought in by the appellants at the time when the respondents had lost their right of reply, which in essence offends the cardinal principle of fair hearing expressed in the Latin maxim Audi Alteram Partem, meaning let the other side be heard as well. Paragraph 4 sub 1 of the first schedule to the Electoral Act 2022 provides that an election petition shall A, specify the parties interested in the petition, in the election petition, B, specify the right of the petitioner to present with specificity the complaints of the petitioner and the relief sought from the court. It gives no room for vagueness and imprecision. This is in line with the rule of pleading that where an averment is not supported by evidence, the averment is deemed abandoned. For in keeping with the Audi Alteram Partem rule, to prevent surprise or ambush on the defendant, it is the plaintiff's claim that will enable him to file his defense. See Wayne West Africa Limited and Ekonife citation supplied, Akonde and Adisa and another citation supplied, PDP and INEC citation supplied. It follows, therefore, that a petition must be detailed and comprehensive on material facts depending on the relief sought, and not evasive or vague, so as to elicit a response from the respondents. Indeed, by the provision of paragraph 16 sub 1A of the first schedule to the Electoral Act 2022, the Act frowns at the introduction of new facts, grounds, or prayers tending to amend or add to the averments of the petition in the petitioner's reply. In fact, a petitioner is only required to file a reply in answer to new issues or facts which may be raised in the respondent's reply, which were not dealt with in the petition. This means that where there are no new issues or facts raised in the respondent's reply, there would be no need for the petitioner's reply. See Oni and Oyebanji, citation supplied. I have critically considered the arguments of parties contained in their respective briefs of argument vis-à-vis the record of appeal. The affected paragraphs of the petition relates to allegation of wrongful cancellation of polling unit results in various local governments in Sokoto State without particulars, manipulation of results in unspecified polling units in some local government areas of Kogi State, wrong results entered for the appellants in unspecified polling units in Borno State, criminal allegations against Honorable Adejo and Governor Yaya Bello without joining them as parties to the petition, open-ended allegation of disqualification against the second respondent, and tying critical allegations of corrupt practices in the election to a statistician report prepared by one Samuel Odutan, that's PW21, without serving the said report on the respondents along with the petition to enable them respond thereto. I am unable to agree with the appellant's argument that the lower court was wrong to have struck out the affected paragraphs for disclosing no particulars, together with some replies in the appellant's reply brief, which sought to bring in new evidence through the back door. I uphold the decision of the lower court striking out the affected paragraphs and replies of the appellants for being vague, imprecise, lacking in particulars, and seeking to ambush the respondent via the petitioner's replies. The ruling of the lower court is unassailable, and this court will not interfere. This issue, again, is resolved against the petitioners. Issue 6 is whether the lower court was not in error in its evaluation of the evidence of the appellant witnesses on the burden of proof and clear admission against interest made by the first respondent. This issue turns on the averment of the first respondent in paragraph 8 of his reply to the appellant's petition that the appellants in this case won the contested election in 21 states out of the 36 states of the Federation, namely Adamawa, Akwa Ibom, Bauchi, Bayelsa, Borno, Delta, Ekiti, Gombe, Jigawa, Kaduna, Katsina, Kebbi, Kogi, Kwara, Nasarawa, Niger, Osun, Sokoto, Taraba, Yobe, and Zamfara states. The appellants contend that such averment is tantamount to admission against interest by the first respondent. They therefore question the declarations to return of the second respondent as the winner of the said election. On its part, the first respondent contended that its said admission is of no consequence, having regard to the fact that the appellant scored 6,984,520 votes, as against the second respondent who scored 8,794,726 votes. That in determining the winner or loser in an election to the office of president, the number of states won by a candidate merit any consideration except in the context of geographical spread and ensuring compliance with the constitutional requirements. In its evaluation of evidence on the issue, the court below on page 8238 of the record had this to say, quote, "The table referred to by the petitioners is the table of results declared by the first respondent. There is no other set of results placed before this court by the petitioners to form the basis of our finding of fact as to whether the declared result is wrong or not. Success or failure in an election depends on figures, which is in turn dependent on votes garnered by each candidate. So, where the complaint in an election petition is that the candidate returned did not poll majority of highest votes in the election to be returned, as contended here by the petitioners, not only must the figures disputed be pleaded, the figures of votes the petitioner perceives as correct figures of the election ought to and must be pleaded. The court went further to hold on page 2854 of the record that, quote, Section 134 sub 2 of the 1999 Constitution talks of the highest number of votes cast at the election if the contest was among more than 2 candidates, as in the instant case, not majority of votes cast as propounded by the petitioners. The first respondent was therefore right from the results declared by her in the absence of any rival or alternative result placed before this court by the petitioners. That the second respondent, who scored 8,794,726 votes as against 6,984,520 votes scored by the petitioners in the election, scored the highest number of lawful votes cast in the election, end of quote. The above statements, qua holding of the court, represent the correct position of the law, and I wholly endorse same. I have earlier in this judgment resolved the issue of electronic transmission of results, which is the main thrust of the appellant's contention in this appeal. I shall not revisit the point under this issue. On the contention that the first respondent's averment that the appellant won 21 states out of 36 states of the Federation, thus constituting an admission against interest, the position of the law is well settled, having regard to who can be declared winner of a presidential election in Nigeria. Section 134, sub 2 of the 1999 Constitution makes it explicit that, quote, a candidate for an election to the office of president shall be deemed to have been duly elected where, there being more than 2 candidates of the election, A, he has the highest number of votes cast at the election, and B, he has not less than 1/4 of the votes cast at the election in each of at least 2/3 of all the states in the Federation and the Federal Capital Territory, Abuja, end of quote. In this appeal, the issue before us is not who among the candidates won in the majority of the states of the Federation, which is debatable, but who scored the highest number of votes at the election. I have strenuously combed through the respective briefs of the parties vis-à-vis the record of appeal. I am unable to find any alternative figure put forward by the appellants as their rightful votes scored in the election, other than the scores presented by the first respondent, INEC, showing that the second respondent scored the highest number of votes. It is presumed correct. In the case of Abubakar and Yaradua, citation supplied, this court held that, and I quote, election results are presumed by law to be correct until the contrary is proved. It is, however, a rebuttable presumption. In other words, there is a rebuttable presumption that the result of any election declared by a returning officer is correct and authentic, and the burden is on the person who denies the correctness and authenticity of the return to rebut the presumption, end of quote. See also CPC and INEC, Buhari and Obasanjo, Hashidu and Goje, all citations supplied. Following from the above, it is clear that the appellants, having not put forward their perceived rightful score to rebut the results put forward by the INEC, the law presumes the first respondent's version as correct. It would not matter whether the appellant can prove having won more states or if the first respondent admits that much. The figures before us show that the second respondent won the highest number of votes and was accordingly returned elected. From whence, therefore, would we manufacture evidence to support the appellant's claim that they scored the majority of lawful votes cast at the election, or that there was non-compliance with the Electoral Act, which affected the credibility of the election? Nowhere, definitely not from the evidence on the record. And that is why this issue is resolved against the appellants. Finally, let me say a few words concerning issue number 7, which is whether the lower court was right in its use of disparaging words against the appellant in its judgment, evincing hostility and bias against the appellants, thereby violating their right to fair hearing and occasioning grave miscarriage of justice. I have read the judgment of the court below, and I've seen the context which those words were used, and it is my view that they were not meant to disparage the appellants or their counsel. As judges, we are trained to be temperate in our use of words, and we shall continue to do so. Litigants are advised to trust the court whenever their matters are before it. It is very unbecoming these days that while a matter is pending in court,
litigants engage in press conferences, analyzing the case, reaching conclusions. Based on this, some of their followers send threatening messages to judges and justices. Matters in court are said to be sub judice, and as such, parties, and probably their counsel, should refrain from media trial and media judgments.
I need not say more on this. A word is enough for the wise. This issue has nothing positive to offer the appellants. On the whole, having resolved all the issues against the appellants, it is my view that there is no merit in this appeal, and it is hereby dismissed. The judgment of the court below,
delivered on the 6th of September 2023, affirming the election of the second respondent as the duly elected President of the Federal Republic of Nigeria, is hereby affirmed.
I shall make no order as to costs. My learned brother on my right will deliver his judgment.
Well, my lords, learned senior counsel and all other counsel, this time around it will not be a 12-hour judgment. So, my Lord, Honorable Justice Okoro has said it all, but we must agree. So, having had a preview of the judgment of my learned brother, John Ian Okoro, JSC, availed me with a copy of the said judgment just delivered in SC/CV/935/2023. Atiku Abubakar and the Independent National Electoral Commission and others. I completely agree with the critical analysis of both the oral and documentary evidence presented before us in this appeal. Therefore, I agree with my learned brother that the motion of the appellants filed on the 6th of October 2023 for leave to the appellants to adduce fresh or additional evidence is devoid of any merit. I also dismiss the same. On the main appeal, my learned brother resolved all the issues, the 7 issues against the appellant. I therefore agree with him that the issues in the main appeal are devoid of merit, and the appeal is accordingly dismissed. And
future arguments in respect of this particular issue. In addition, the issue of a candidate scoring 1/4 of votes in the FCT has also been settled by this court before now. And it is in line with that decision and position that the lead judgment had affirmed that the FCT is not elevated to a higher pedestal than any of the states of the Federation. It is, for the purposes of the presidential election, one of the states for which a candidate is required to obtain at least 1/4 of the votes in 2/3 of each of the states. So I totally agree with the judgment that this court lacks the requisite jurisdiction to entertain the application for leave to produce fresh or additional evidence, and that this appeal is also lacking in merit and deserves to be dismissed. I also dismiss the appeal, and that will be my judgment in this appeal. I abide by the consequential orders made in the lead judgment on cost to be borne by the parties for the prosecution of this appeal.
My little brother, Salawa, will deliver his judgment.
My learned brother, the Honorable Justice Okoro Jesse, has accorded me the opportunity of a preview of the judgment that he has just delivered. I must say that I have read that judgment, and I'm very much content and appreciative of the far-reaching, erudite reasoning and conclusion that have so far been reached in the lead judgment. I concur with the highest sense of responsibility with the reasoning and conclusion reached therein. With particular regard to the interlocutory application, thereby urging upon this court to grant leave to the appellants to procure and transmit and adduce fresh or additional evidence at this crucial point in time of the appeal. I concur most assiduously with the conclusion that has been reached in the judgment of my learned brother that such an application is grossly unmeritorious, thus ought to be dismissed, and same is accordingly hereby dismissed by me. And as for the substantive appeal itself, which has been predicated upon a total of 7 issues, I agree entirely with the reasoning eruditely expressed by my learned brother that each of the 7 issues that have been canvassed and argued by the appellant are grossly meritorious, that ought to be resolved against them. Without much ado, I hereby accordingly dismiss the appeal for being grossly unmeritorious. As usual, it is not the time for us to read elaborative judgments. Just like my learned brother said, 12 hours. We're not going to do that because learned counsel representing the respective parties in this appeal will have every opportunity to be served with the complete judgments of each and every justice of this panel in due course. Because constitutionally, we have a total of 7 days within which judgments must be served on the respective learned counsel that appeal. Thank you very much.
My Lord Jaro, read your judgment.
Thank you. Well, I have had the privilege of reading before now the lead judgment delivered by my learned brother, John Ian Okoro, JSC. His Lordship has ably considered and resolved all the issues in contention in the appeal, as well as the application. I agree with the reasoning and conclusion reached therein to the effect that the appeal is bereft of merit and deserves a dismissal. The application, too, is not meritorious. Accordingly, I dismiss the application and the appeal. That is my position.
My Lord Abubakar.
I thank my Lord the Presiding Justice, Honorable Justice John Ian Okoro, for granting me the privilege to read in draft the lucid and illuminating leading judgment just delivered in this appeal. I start with the application. The application seeking to adduce additional evidence or fresh evidence, I also find it lacking in merit. The application is frivolous and vexatious. It deserves to be dismissed, and it is hereby dismissed. Now, coming to the substantive appeal, I find no merit in the substantive appeal. It is also dismissed. On the whole, therefore, the appeal is dismissed and the judgment of the lower court is affirmed. Parties in this appeal shall bear their respective costs.
Yes, Iroko. Agim, JSC.
With the kind permission of the learned presiding justice, let me also express my view. I had a preview of the judgment delivered by my learned brother, Lord Justice John Inya Okoro, JSC CFR. I completely agree with the reasoning, conclusions, decisions, and others therein. And I must remark that it is bristling with commendable erudition. Let me, however, say maybe one or two things, since we will have opportunity, you will have opportunity to have our views. That the deposition is, for this additional reason, inadmissible. So if a document is inadmissible, you cannot ask that you should be allowed to bring it in as fresh evidence. A reading of the deposition exposes that it is not authenticated by the seal of the authority before whom it was issued. A deposition from another country to be used in Nigeria should prima facie bear features of authentication, such as the official seal of the court where it is sworn if it is the court, or if it is before a notary public, his seal or signature, or if sworn before a person legally authorized to take the seal, or if sworn in the Nigerian Embassy, High Commission, or Consulate in that country, the signature of the officer authorized to do so, and the seal of the Embassy, High Commission, or Consulate. Such authentication is an assurance of the origin and authenticity of the foreign disposition. In our present case, the certified shorthand reporter, before whom the deposition was made, did not authenticate the deposition with her seal. She merely signed her certificate of reporter, bearing her name and number, page 126 of Exhibit C. Being a deposition from another country, it cannot be used in Nigeria without authentication. The authentication of the oath administration is mandatory. I have wondered why the deposition said to be made pursuant to the 3rd October 2023 order of the United States District Court for the Northern District of Illinois in case number 23 CV 05099 for use in a foreign country was not made before the court in the said proceedings. And if made elsewhere in the law office of the first appellant's attorney, why was it not filed in the above-mentioned court because of the peculiar circumstances of this case, and adopted as a deposition ordered to be made by the court, so that it can form part of the record of that court to enable the court issue it as part of its record, also authenticate it with the seal of the court and the signature of the relevant officer of the court. Page 1 of the deposition is headed in the United States District Court for the Northern District of Illinois in reapplication of Atiku for an order directing discovery from Chicago State University pursuant to 28 U.S.C. 1782 number 28 CV 05099. This gives the impression it is a process of the District Court, or that the deposition, though made outside the precincts of that court in a private law office, is part of the proceedings in case number 23 CV 05099. If it is indeed a process of the said district court, or forms part of the proceedings in case number 23 CV 05099 before it, then it ought to have been authenticated by the official seal of the court and the signature of the relevant officer certifying it as a true copy of the part of the record of the court in case number 23 CV 05099. Without such authentication, a deposition cannot be used in the Nigerian court as part of the proceedings or in the said U.S. District Court. And I've continued to wonder why the college, why the appellant did not use the advantage of the order of the district court that the college produced documents and a deposition concerning those certificates. Why they didn't use that advantage to secure a letter from the college under its letterhead, seal, and signature, disclaiming the certificate presented by the second respondent to INEC as not one issued by the college. That was not done. Instead, they resorted to this deposition, which has no features of authentication, thereby rendering it spurious and inadmissible. I agree with the able manner the lead judgment has dealt with it. I agree totally with all the reasons given in that decision as to why such an application should be refused. And it emphasizes one point, It was obvious to all, including those who brought it, that it was going nowhere. Then the question is, why was it brought? And I agree with my Lord when he described it as a vexatious process. I dismiss the application too. I go to the appeal. I agree completely with the lead judgment. I cannot say it better than that. It was a real brilliant expose on all the issues raised. Let me also join my Lord Garba to talk about a question of Abuja and 1/4 of the votes there, that the candidate must win. They view that the provision of the Constitution should be applied in such a way that the votes in Abuja must be won. 1/4 of the votes must be won by a candidate before he can secure victory in election. To me, violates a fundamental principle of constitutional interpretation, that it must be interpreted to protect the spirit of the Constitution. And if you look at our Constitution, it promotes egalitarianism, equality. So it must be applied in such a way as to protect the equality of the votes in all the entities, and not otherwise. I will expand on that in my judgment. So I do not agree with the interpretation placed upon it. Attractive as it may be, but we must bear in mind that there's no jurisdiction in the world where a constitution is read in isolated patches and given meaning that should have very narrow meaning that should appeal to certain sentiments. No, you apply it as a whole, reading it completely together, so that you rely on one part to get a meaning in another part, that the words can truly support the wordings used in that provision. That is how to read a constitution. Yet remembering that it is dealing with a dynamic system, a human society. For these reasons, I also dismiss the appeal. I also agree that the parties should bear their costs. Thank you very much.
Thank you, my lord. We are now left with the next appeal. I call the next one.
SCCV 937-2023, Mr. Peter Gregory Obi, Labour Party, Appellants, Independent National Electoral Commission, INEC, Senator Bola Ahmed Tinubu, Senator Shetima Kashim, All Progressives Congress, APC respondents.
Appearances.
The Lordship, my name is P.I.N. Ikweto. My Lords, unfortunately, we have a type list of counsel, and by the time my colleagues brought it to the registry, they were told it was late. If your Lordship allow me, can I submit that list?
Please, sir, submit it.
Thank you, my Lord, sir. And my Lords, with respect,
judgment day, we don't go late to court.
I was here before. I was here by 8 o'clock, sir.
So that you won't be late when God will be giving judgments.
Oh, my Lord, on the day of my own judgment before the Lord, I will be there alone. So I will never be late there.
So,
and I'm sure you will accept me when I get there, sir.
God will accept you.
I'm sure he will.
I pray it should be so.
Amen, sir. My Lord, I want to say that my name is P.I.N. Ikweto, and your Lordship, with respect, we have, in line with your Lordship.
I think we should start calling you Saint Ikweto.
My Lord, I cannot be while still on earth. Yes, sir.
Until you die.
While still on earth, I cannot be. I'm a sinner.
Let's find a place and discuss that.
I Lordship, please. My Lord, I don't know where we can discuss that, sir. My Lord, we've taken the liberty to tick the names of my colleagues who are with me.
Azinge.
Number 3, Dr. Mrs. Valerie Janet Azinge, SN. Number 4, my lords, Alex Ejesieme, SAN.
Azinge.
Yes, sir. Azinge is number 3, sir.
Yes.
Number 4, my lord, is Alex Ejesieme, SAN.
Where is Azinge?
My lord, Azinge is just beside me here. She's been here all morning with me.
Azinge used to be black. I don't know why she's white today.
No, she's always been fair complexion. Always. Yes, sir. The husband is dark complexion.
Okay, it's the husband that is dark.
As a lot of places, yes, sir. But she's been fair complexion all along.
It's okay. You're welcome.
Yes, my lord.
Leonard SN Equator, did you say Valerie is number 3?
My lord, on the list, she's number 3.
But she's number 2.
She's number 2, yes, sir. Yes, sir. I just want to make it easier for my lord, sir. The next, my lord, is Mr. Alex Ejesieme, SAN.
Yes. Chike.
My lord, as a Chike AOB Esquire.
Yes.
And my lord, lastly, and in compliance with my lord's directives, Ejiofor Onwaso Esquire. Your lordship, the appearance with due respect is for the appellant in this appeal.
Yes.
Yes. Please, my lords. I am Sir Stephen Adehi. I am number 2 on the list.
Where is your list?
We submitted a list this morning, my lord.
Stephen
Adehi, my lord. Okay. Sir Stephen Adehi.
Leave that thing. Adehi.
Yes, my lord.
Yes.
I appear with my learned friends of the inner bar.
Yes, yes.
Al Hassan A. Umar, SAN, is number 4 on the list.
Umar.
Yes, my lord.
Yes.
And number 7 is Wendy Kuku, Esquire, my lord.
Yes. Yes.
Number 8, Jamiu Aguru, Esquire.
Where is Jamiu Aguru?
And finally, number 10, Z.U. Obansa, Esquire. Our appearance, my lord, is for the first respondent. May my lords be pleased.
Yeah, for the... Yes? Tell those guys, tell them that this thing can amount to contempt of court, so they should be careful.
My lord, the last person on our list, my lord, is actually number 9, Amira Hamisu, not Obansa. Number 9.
Who?
Amira Hamisu, Esquire. Yes, my lord. Not number 10, my lord. Thank you very much, my lords.
1, 2, 3. Amira. Hamisu. Yes?
If it pleases my noble lords, my name is Akintola Makinde, and I appear with my colleague, Okpe Moritala. Your lordships, we submitted a typewritten list in the morning. Very respectfully, our appearance is for the 2nd and 3rd respondents. We are very grateful, sir.
Okpe.
Okpe Moritala, my lord, is number 2 on the list here.
Yes.
We are very grateful, sir.
Yes. Yes.
Respondent.
Yes.
Appearing with me, I'm learned friends. My lord, I'm sorry, the next name is not on the printed list which we submitted.
Let me, okay, here.
Professor Abdul Karim Kana. And Abdul Wahab Abayomi. We all respectfully appear for the 4th respondent. How much obliged, my lord?
For the 4th respondent.
Respectfully, my lord.
Yes, well, in this appeal, we have, during conference, noticed that issues number 1, 2, 3, 5, 6, and 7 in this appeal have been dealt with in Atiku's appeal. It is the decision of this court that this issue shall abide the outcome of the issues as resolved in Atiku's appeal, mutatis mutandis. As for issue number 4, which has to do with double nomination, which was not in Atiku's appeal, it is the view of this court that this issue, having been dealt with by this court in S6 to CB, to 501 to 23, which judgment was delivered on the 26th of May 2023, this court cannot allow the matter to be relitigated in this very court. There must be an end to litigation. For us to sit down now and talk about when this man resigned or did not resign, when they did a fresh conference or fresh primaries to replace him, which we have done before. We are not going to do it again. This matter ought not to have come here. When the matter was pending at the trial court, this court delivered that judgment. If you read the judgment of the lower court, they mention it, that Supreme Court has settled this matter. And that should have been the end. You now bring this issue of double nomination for us to sit on it and write another judgment this is not how it should be. This appeal lacks merit and is hereby dismissed. My Lord, to my right, Abaji.
I agree with my learned brother, Justice John Ian Okoro, that this appeal, number SCCV 937, 2023, Mr. Peter Gregory Obi and the Independent National Electoral Commission lacks merit, and it is also dismissed by me.
My Lord, Garba Jesse.
I also totally agree with the lead judgment that this appeal substantially canvass the same issues with the appeal number 935, 2023, which this court has very comprehensively dealt with. And there is no need for us to repeat ourselves because the issues are the same. The only issue that's different, like pointed out by my learned brother, the PJ, is that about double nomination, which you have settled. And we do not intend to reopen it again in this appeal. On the whole, I also join the lead judgment to dismiss this appeal for lacking in merit.
My Lord, Salawa.
Having had the privilege before now of reading a draft, the judgment prepared and delivered by my learned brother Okoro JC, I cannot but concur with the far-reaching reasoning and the conclusion that has been postulated in the judgment to the effect that the instant appeal lacks merit, thus ought to be dismissed by this court. Having associated myself with that reasoning and the conclusion, I have no hesitation whatsoever in dismissing the appeal. Appeal dismissed.
My Lord Jauru.
Well, I had the advantage of reading in draft copy of the lead judgment just delivered by my learned brother, John Ian Okoro JSC. I entirely agree with the reasoning and conclusion contained therein that the appeal is devoid of merit and it ought to be dismissed. Consequently, I join my brother in dismissing the appeal.
My Lord Abubakar Jesse.
I also had the advantage of reading in draft the judgment of my learned brother Ian Okoro JSC, and I am of the view that the appellants have nothing useful to urge this court. The appeal lacks merit, and it is hereby dismissed by me.
My Lord Agim Jesse.
I had a preview of the judgment delivered by my learned brother, Lord Justice John Ian Okoro. I completely agree that this appeal lacks merit and it should be dismissed. I hereby dismiss it.
Thank you all for listening. The two appeals, I think we have concluded our job today. What remains is for us to go and rest. Thank you very much. We shall rise.
Ella.
Without any dissenting voice. Like the judge said, all litigation must come to an end. They addressed all the issues, about 7 of them, and those issues were, and the judgments on each of the issues is clearly, or were clearly unassailable as far as I'm concerned. So for me now is the time for us all, every Nigerian, particularly the president, to roll up his sleeves and continue with the governance. This has been a distraction. The litigants exercise their rights to go to court, but that has come to an end now. We now have to all come together as one country, one people, and move ahead and take this country where it rightfully should be. We're happy. We're excited.
So coming together, does
yes.
that mean that you'll be extending a hand to the PDP and the Labour Party? Although the APM's appeal was dismissed, but would the president be extending a hand of friendship or sportsmanship to the other political parties?
Well, listen, we shouldn't take these things personal, right? If you listen carefully to the judgment was very sound. By any objective, right-thinking person, supported with facts, with cases, with statute. The president, if you know him very well, is a Democrat. It's not now that he's extending his hands of fellowship. He's always done that. He will continue to do that, and will continue to do so on his behalf. Governance is about everybody. It's not about a party. It's not about an individual. And if we do not come together now, then we'll have ourselves to blame. Opposition is not, you don't oppose for the sake of opposition. Elections are over, litigation is over. All litigation must come to an end. Now is the time for governance. Distractions over. So yes, Mr. President, the APC, and all rightful thinking members of the society must come together, no matter what party you belong to address the issue of governance.
Thank you very much.
Thank you very much.
Sir. Excellent.
Okay. Well, I want to first give all the glory to Almighty God for this judgment. It is indeed another day that the Lord has made. We're glad that this puts an end to all litigation and a closure to all the speculations and all that. Mr. President, in his magnanimity, I'm sure will now again reach out to all to join hands with him in his renewed hope agenda. APC was his platform, but the Nigerian state is where he's president of. So this is not just a victory for our party APC, it's a victory for the country. And we want to salute the judiciary, starting from the Supreme Court, the Appeal Court. Their judgment was very detailed, it was very meticulous. It laid the foundation for the Supreme Court judgment. I want to salute the judges of the Supreme Court as well. It was straight to the point. And I believe that this judgment would be seen worldwide as that which is in line with global best practices in law. I want to salute them again because, they are the bastion of hope for everybody, including the common man. And This is a victory for democracy. Opposition can now go and rest. If they indeed mean well for this country, I expect that after today, they will call President Bola Ahmed Tinubu. They will congratulate him. They will now sit down and fashion out how to join hands with him in ensuring that indeed we achieve and continue to achieve our pride of place in the Committee of States across the length and breadth of the world. Once again, I congratulate President Bola Ahmed Tinubu for this victory, and I congratulate APC. I congratulate Nigeria. Thank you very much for having me. Thank you.
Yes, just one question.
Okay, what is it? Yes.
The court today said that the FCT has no special status. As the minister of the FCT, what do you have to tell me?
Maybe you don't understand when he said FCT has no special status. What he said that in terms of calculating or having the status quo, you must not win FCT before you are declared president of the Federal Republic of Nigeria. That FCT is like another state. So that you don't need to say, oh, if you don't win FCT, therefore you cannot be declared. That's what he said.
So you must step this out with the APC crew. Can we say that you have moved to the APC?
I didn't come with APC crew. And in the court here, in the court here, I don't know where they said APC and PDP. I came here as somebody who's interested, as somebody who wanted the country to move forward. So I congratulate Mr. President, and I think that this has come to the end. No more speculation. As well, Mr. President can focus and do what he's supposed to do for Nigerians. Thank you.
Thank you.
I just want to Chairman.
Election litigation and the delay it seems to constitute election litigation and the delay seems to constitute distraction. Will you be moving for some form of amendments?
Well, you see,
what is your advice to your opponents?
well, you see, this is a developing democracy in a developing nation, so you expect such distractions to occur. But I believe we fine-tune our laws, especially electoral laws, and we believe we shall come to the mature stage that we are expecting. Pertaining to acceptance of this verdict, I urge our colleagues, politicians, to accept it in good faith. And also I have to use this opportunity to congratulate politicians, to congratulate the leaders of the opposition political parties, because it is better for them to resort to judiciary, which they have done so, rather than taking, arms against against each other. Yeah. So we have to congratulate our politicians for resorting to judiciary, and the judiciary has done well. It means that democracy is getting matured in Nigeria, and we are happy with that.
Many thanks, sir. Thank you.
I don't know the process yet.